The majority of those who participated in the protest were animated by a genuine desire to engage in peaceful demonstrations so that their voices would be heard by leaders in government. They wished to exercise their fundamental right to express their political views, and they had a right to do so. However, like any large group, there were a diversity of views and intentions among the participants of the Freedom Convoy. Amongst the many who intended to protest peacefully were others who had more sinister goals or who were willing to engage in dangerous conduct to achieve their desired ends. For reasons that I discuss in my report, what began as a massive protest evolved into something entirely unprecedented, an occupation of the core of the nation's capital. En janvier et en février 2022,
the events of January and February 2022 were not limited to Ottawa. As I describe in my report, protests were occurring across the country in places such as Coutts, Alberta, Emerson, Manitoba, and Windsor, Ontario. These protests were also diverse. They ranged from peaceful marches to blockades of critical infrastructure. The size and scope of these protests was truly unprecedented. Police and governments alike struggled to respond. Ultimately, the federal government's response was to declare a public order emergency.
Is what role I should play in assessing Cabinet's decision to invoke the Emergencies Act? There's no precedent that helps to answer that question. Some parties have argued that I should not opine on the appropriateness of the decision and whether government met the statutory requirement to declare the public emergency order was not within my mandate. They note quite properly that determining the legality of the government's actions is the role of the courts of law. Others, however, have argued that pronouncing on the decision is the raison d'etre, the very reason for this commission. In my view, the role and focus of a commission of inquiry into the use of the Emergencies Act will depend, to a certain extent, on the context in which the Act is invoked. In some instances, it may be beyond doubt that the conditions for invoking the Act were met. But there may be other questions that require careful review. In the present situation, however, I'm faced with a statute that has never been used or judicially interpreted. Serious questions have been raised as to whether the legal threshold to use the Act have been met. My assessment of the circumstances surrounding the invocation of the Act, therefore, inevitably involved a consideration of the Act's requirements. While nothing in my report is in any sense binding on the courts that may hear legal challenges to the use of the Act, I have decided to set out my own views on the invocation of the Act and the measures taken under it. After careful reflection, I have concluded that the very high threshold required for the invocation of the Act was met. In particular, for reasons that I discuss in detail in the report, I have concluded that when the decision was made to invoke the Act on February 14th, 2022, Cabinet had reasonable grounds to believe that there existed a national emergency arising from threats to the security of Canada that necessitated the taking of special temporary measures. I do not come to this conclusion easily, as I do not consider the factual basis for it to be overwhelming. Reasonable and informed people could reach a different conclusion than the one I have arrived at. Après
careful reflection, I have concluded that the very high threshold required for the invocation of the Act was met. In particular, for reasons that I discuss in detail in the report, I've concluded that when the decision was made to invoke the Act on February 14, 2022, Cabinet had reasonable grounds to believe that there existed a national emergency arising from threats to the security of Canada that necessitated the taking of special temporary measures. I do not come to this conclusion easily, as I do not consider the factual basis for it to be overwhelming. Reasonable and informed people could reach a different conclusion than the one I've arrived at. I also reached this conclusion reluctantly. The state should generally be able to respond to circumstances of urgency without the use of emergency powers. It is only in truly rare instances, when the state reasonably believes that it cannot otherwise fulfill its fundamental obligation to ensure the safety and security of people and property, that resort to emergency measures will be appropriate. In other words, the Emergencies Act is not a tool of convenience, but rather it is a tool of last resort.
The fact that circumstances evolved to the point where Cabinet reasonably considered it necessary to invoke the Act is regrettable, because in my view, the situation that led to its use could likely have been avoided. As I explained in my report, the response to the Freedom Convoy included a series of policing failures, though I have also identified sound practices employed by some police services in their response to relevant events. Some of the missteps may have been small, but others were significant. Taken together, they contributed to a situation that spun out of control. The failures were not only in policing. Preparing for and responding to situations of threat and urgency in a federal system requires governments at all levels and those who lead them to rise above politics and collaborate for the common good. In January and February 2022, this did not always happen. Had police forces and governments better anticipated and prepared for the extent of political and social discontent exacerbated by COVID-19 pandemic, particularly in the environment of misinformation and disinformation so prevalent today, and had they collaborated more effectively, there could have been a different response to this unprecedented situation. It's likely that such preparation could have avoided the necessity of invoking the Emergencies Act.
In addition to making findings on the invocation of the Act itself, I've also reached conclusions on the appropriateness and effectiveness of the measures taken under it. While I have ultimately concluded that the federal government was justified in invoking the Act, I reach a more qualified conclusion with respect to the measures that the government adopted. I determined that the measures taken by the federal government were, for the most part, appropriate and effective, and contributed to bringing a return to order without loss of life or serious injury to people or property. I also found, however, that in a number of respects, these measures were deficient. These included important aspects of the Emergency Economic Measures Order, such as the absence of any discretion related to freezing assets, and the failure to provide a clear way for individuals to have their assets unfrozen when they were no longer engaged in illegal conduct.
I determined that the measures taken by the federal government were, for the most part, appropriate and effective, and contributed to bringing a return to order without loss of life or serious injury to people or property. I also found, however, that in a number of respects, these measures were deficient. These included important aspects of the Emergency Economic Measures Order, such as the absence of any discretion related to the freezing of accounts or assets, and the failure to provide a clear way for individuals to have their assets unfrozen once they were no longer engaged in illegal conduct. J'ai aussi abordé les aspects du règlement
I
sur les
also
mesures
discuss
d'urgence qui
aspects
me
of the emergency measures
notamment le
regulations
caractère vague
that cause me
de ces
concern,
dispositions
including the
relatives à
vagueness of its provisions
l'aménagement des
related
lieux
to
et son
securing of
impact
places
potentiel
and its
sur la
potential
liberté de la
impact on
presse.
freedom of the press.
Mon rapport s'appuie sur les
Drawing
leçons
on lessons
apprises au
learned
cours de
through
cette
this
enquête
inquiry,
et offre
my report
56
concludes with a set of
recommandations
56
couvrant 6
recommendations.
grands thèmes.
My recommendations
Le
relate to
maintien de
6
l'ordre
broad
dans la police,
areas:
la
policing,
collecte et la
federal
coordination
intelligence
du
collection
renseignement
and
au palier
coordination,
fédéral, les corridors
critical
commerciaux et les
trade corridors and
infrastructures
infrastructure,
essentielles, la réforme de la
reforms
loi
to
sur
the
les mesures
Emergencies
d'urgence,
Act,
les autres questions
other
à
areas for
approfondir
further study,
et la
and
responsabilité de
follow-up
rendre
and
compte suite au rapport.
accountability following the release of my
Drawing
report.
on lessons learned through this inquiry, my report concludes with a set of 56 recommendations. My recommendations relate to 6 broad areas: policing, federal intelligence collection and coordination, critical trade corridors and infrastructure, reforms to the Emergencies Act, other areas for further study, and follow-up and accountability following the release of my report. I hope that these recommendations will go some way to addressing the various issues and deficiencies of a systemic nature that I identify in my report. Before ending these remarks, I would like to make a few comments about the Emergencies Act itself. I have already commented that it is regrettable that the situation across Canada deteriorated to the point where Cabinet reasonably believed that the use of the Act was necessary. We can all hope that such an exceptional confluence of events and circumstances does not occur again. However, even if it does, and if once again the very high threshold for declaring an emergency is met, members of the public should recognize that the Act contains significant safeguards. Although the Emergencies Act is often referred to as a replacement for the War Measures Act, it is in fact a very different statute. The Emergencies Act was designed to respond to a much broader range of emergencies. It was also intentionally designed to provide extensive checks, balances, and limits to guard against abuse. Il existe en effet des restrictions notables quant au type.
There are significant limits on the kinds of measures that the government can take during an emergency. The law permits legal challenges to use of the Act, and the measures adopted under it must remain compliant with the Canadian Charter of Rights and Freedoms. Parliament is given extensive powers of review and control over the executive's use of the Act. Although Cabinet can unilaterally declare an emergency, Parliament can revoke the declaration at any time. And of course, a commission such as this one is mandatory. Provided that future commissions are, like this one was, created pursuant to the Inquiries Act and given access to the necessary documents and information, they will ensure that the government's conduct will be subject to meaningful, independent scrutiny. It is notable that the protections that the Emergencies Act contains far exceed those of any provincial or territorial emergencies statutes in Canada, and even in other countries across the world. While I have made recommendations for various reforms to bring the Emergencies Act into the 21st century to ensure the effectiveness of future inquiries and to strengthen government accountability, I am also convinced that there is much in the Act that is commendable. The Parliament that passed the Emergencies Act in 1988 went to great lengths to ensure that its use would be subject to robust accountability and public scrutiny. I hope that this inquiry and my report have contributed to achieving this.
The Parliament that passed the Emergencies Act in 1988 went to great lengths to ensure that its use would be subject to robust accountability and public scrutiny. I hope that this inquiry and my report have contributed to achieving this. Merci beaucoup. Thank you. Enjoy the report.